Okay, good morning, everyone. It's 9 o'clock, so we'll go ahead and get started. Thank you all for joining us for our June Brunch and Learn webinar, our monthly webinar. This month, we've decided to do another what we call open office hours. It just gives our members a chance to jump on and ask questions about timely topics or issues that are arising in your district, and for everyone else to listen to kind of hear what's going on in all in each other's districts. I think that can be quite helpful sometimes, to listen to issues that are happening in other districts and how they're handling it. So I'm just going to share my screen. Just give me a second here. All right. There we go. Okay, hopefully you all can see that there. So kind of how we've only done this one other time, and what we did was kind of flag some topics for kind of timely topics to, flag some questions and invite questions on. And those you can see here on the screen. Post-election duties and responsibilities, canvassing of election results. Most districts will be, their boards will be canvassing next Monday, I believe, on the 24th of June. That's if you had your election on the second Tuesday in June. And so canvassing is coming up next week. Annual meetings will be happening in July. And so those are the kind of three topics that we flagged. But frankly, we're kind of open to hearing whatever questions you have and want to hear about and want to ask about. So feel free to do that. We've set aside about an hour. We'll see how long we go today. Last time we went the full hour, so we'll see. We have a number of people on today. So I think the way we'll do this is if you have a question, feel free to put that on the, let's see, do we have Q&A feature? I just can't see it on mine. Oh, there we go. Okay, so yes, so we'll do the Q&A feature. So if you have a question about any of these topics or anything else that's happening in your district, feel free to ask it in the Q&A. And then we'll go ahead and get started. So feel free to go ahead and start asking your questions. I came prepared just in case, just to kind of get the discussion going this time. So just a couple of reminders on post-election duties and responsibilities. Between your election and your annual meeting, I call the old board can still meet and take action if necessary. Usually we have a June meeting in a lot of districts that's occurring after that annual election. And, that's the old board. The terms continue until the annual meeting in July. And so it's appropriate and proper to meet between the election and the annual meeting, especially for your regular meeting in June. I do generally encourage boards to consider what they're meeting about. Is it business that can wait until the new board is seated? Think about that when you're deciding whether you should hold a meeting. But things come up unexpected during that time, and so calling a special meeting is perfectly appropriate. But I do invite you and encourage you to consider, is that something that can wait till July or till the new board is seated? Especially if the new board is going to have to consider it or be involved. Sometimes it's good to wait until that new board is seated, but things do come up. Another thing is that you may still be receiving as business managers. I know we have a number of business managers on today. You still may be receiving absentee ballots after the election. The important thing to remember is that absentee ballots must be postmarked no later than the day before the election in order to be able to be counted and processed. But that does happen, you know, with the mail these days. Sometimes it takes a long time in certain areas of the state. And so you might still be receiving those absentee ballots. If you do receive them after election day and after the judges count on election night, those are just kept secure until the canvassing meeting on the 13th day following the election, and then the canvassing board will then process those and decide whether they should be counted or not. Remember that absentee ballots with no postmark or that have an illegible postmark must be received by mail by the business manager prior to the canvassing meeting in order to be considered or processed. And then the canvassing board will then determine whether those ballots should be counted or not. During this time also, you know, again, between kind of your annual election and your annual meeting, or actually between the canvassing meeting, your business managers should be preparing for canvassing. And we'll go through that here in a minute on what that looks like, but that's kind of what's happening as well. All of your election materials, your ballots, your poll books should be kept, secured, and stored in a fireproof location until that canvassing meeting. And then also, if you have signature mismatches on the application between the voter, or excuse me, the application for absentee ballot and the voter affidavit on the back of the return envelope, if the signatures were determined to not match when they were processed prior to the judges count, the business manager is required by law to notify the voter and provide an opportunity to cure the defect. And really what that means is an opportunity to confirm that, yes, that's my signature on the voter affidavit and the application. Those are my signatures. And we'll go through that too here in a second. But that's the time frame where you're contacting voters who may have had a signature mismatch on their absentee ballot application and the voter affidavit on the back of the return envelope. And then the canvassing board on canvassing night will then receive information from the business manager on any signature mismatch ballots and confirming whether the voter confirmed their signature or whether the voter did not come in and confirm. We'll go through that in a second. I'm just going to look at the Q&A. We have a few questions. So the first one, what happens if an absentee voter initials their own ballot? This is a good question. I actually just, oops, sorry. So there is a provision in the law. I don't have it in front of me, but it's in the elections title of the code that said if the ballot is not properly initialed, it's void. And so if the voter has, so there is a space on the ballot, on the bottom of the ballot, where the judge is supposed to initial the ballot. And if that is not properly initialed by an election judge, the law directs that it's void. And so if you receive an absentee ballot and it's initialed by the voter, I would set that aside during processing so that the canvassing board can then consider that issue at the canvassing meeting and decide whether it should be counted or not. And again, the law directs, and I can get that, Katie, I can send that section of the code to you by email so that you have that. But that's what the code directs. Okay. And then we have some questions about the canvassing process. I'll get to that here in a minute, and we'll kind of explain what that looks like. Okay. Okay. So I wanted to address the signature mismatch process because it's been in the code for the last handful, maybe less than a handful of election seasons, but it is still something that I think, you know, a lot of folks haven't run into yet. But essentially, during the processing of absentee ballots, when you receive an absentee ballot back from the voter, you are, you know, before you start processing, you're going to identify the application of that voter and then attach the return envelope with the ballot inside to that application, so that it's prepared for processing. Processing can start anytime at least 3 business days prior to election day, and then all the way through the closing of the polls on election night. That's when you can process that. I won't go through the processing of absentee ballots, but during that process, one of the steps is to compare the signature from the application with the signature on the voter affidavit that's on the back of the return envelope that you receive back from the voter with the ballot inside. If those two signatures do not match, the law requires that essentially you set those aside, and the business manager is then required to contact the voter following processing after election night, and give the opportunity for the voter to cure the defect. In other words, to confirm the signature. And what the law requires is that that contact first must be attempted by phone if you have a telephone number on your application or your voter affidavit. On the suggested language that we have in our election handbook, we do have a place for them to put their phone number for that very reason, so that you have an ability to contact them by phone if the voter affidavit is incomplete or the signatures don't match between the application and the voter affidavit. If you can't reach them by phone, you are required to mail a notice to the voter informing them of the signature mismatch. And then I've included a number of items that the notice has to include. It has to include instructions by which the voter can confirm the validity of the signatures, a statement that the verification is required before the ballot can be counted, the date and time of the canvassing board meeting, because again, the confirmation of the signatures has to happen prior to that canvassing meeting in order for that ballot to have an opportunity to be counted. And again, you have to have a statement on there that that verification must be completed before it says before the close of the canvassing meeting. Frankly, I would say before the canvassing meeting on the 13th day after the election. The way that they can cure is they can do it in writing or in person. If they do it in writing, they have to include a copy of the identification that they used when applying for the ballot. So if they use their driver's license, they have to include a copy of that so that you can confirm that this is the person confirming the signatures is the person that applied for the ballot. If they do it in person, they have to bring and present their identification that they used in completing the application, so that you can confirm that this is the right person. And essentially all they need to do is confirm, yes, this is my signature. No, these aren't my signatures. If the signatures are confirmed by the voter, the law requires that the school board include that ballot in the final canvass. Now that's assuming that you can you know, that the ballot is filled out correctly and you can determine the voter's intent by the ballot. But if that's the case, the law requires that it be included in the final canvass. Okay, so we had someone asked to go through the canvassing process. I don't have it in detail on this slide, but if you don't have our election handbook, I know the person that asked is a new business manager. If you don't have our election handbook, shoot me or Taylor, who is also on on today from our office, shoot us an email and we'll get you a link or to that election handbook. And it has a detailed step-by-step process of the canvassing board or the canvassing meeting in that handbook. And so it's a good resource to have to look back on each year. But just to kind of go through to summarize what the canvassing process looks like, canvassing has to occur on the 13th day following the election. And there is no discretion in that date. It's not within 13 days. It has to happen on the 13th day following the election. And for most boards this year, that's going to be on Monday, the 24th, because most boards have their annual election on that second Tuesday in June. Okay, it looks like Taylor put up a link to the election handbook in the chat. So thank you, Taylor, for that. So you can download that handbook, the most recent version of the handbook, in the chat at that link. Back to the 13th day issue. I get this question every year. What if, some of the board members can't meet? What if somebody's out of town? What do we do? You have to have the meeting on the 13th day. That's the requirement. So if a board member is out of town, can they meet? Can they appear by phone? Can they appear by Zoom? I would do what I can to get all of the board members there and present on canvassing night. But all you need is a quorum of the board to meet and canvass. So if one of your board members is missing and they can't appear by phone or by Zoom or something similar, but you have a quorum there, you can go ahead and meet and canvass the election results. And what the purpose of the canvassing is to finalize the election. Something important to remember is the canvassing meeting is just like any other meeting of the board. It's an open public meeting that has to be properly noticed. So make sure that you are noticing that. Typically, the timing doesn't work out for it to be your your regular meeting for the month, although maybe that's something that you plan for in setting your regular meetings. So typically it's going to be a special meeting of the board. And so you'll want to make sure you comply with all of the special meeting notice requirements. And again, those are all found in section 440420 of the code. And really what the canvassing meeting is really the business manager kind of guiding the board through the canvassing process. Usually it starts out, or at least it's recommended to start out by the business manager reporting on the election, including like what number of voters voted, how many ballots were cast, how many votes were received by each candidate for each office that were on the ballot. If you had any questions on the ballot for your voters, what were the results of the questions? How many voted yes? How many voted no? Whatever the case may be. And then also, I think it's important to also report on the number of absentee applications that were received and how many ballots were then voted and received. Oftentimes, you don't get all of the ballots back that you sent out. And so it's good to keep a record of how many applications were received, and then how many ballots were then voted by those folks that received absentee ballots. And then the other important part of the canvassing meeting is making any necessary rulings on ballots that may have been set aside during the judge's count on election night. So for example, if you had a ballot set aside because the voter was not a qualified elector in the district, and that's usually going to be an absentee ballot. That would be set aside for the business manager to report to the board on canvassing night. If the board confirms yes, this elector or this voter is not a qualified elector in the district, that ballot can't be counted. The board would then make a ruling on that. Motion, second, and roll call vote to not count that ballot because, for example, the voter was not a qualified elector in the district. Again, a qualified elector, you have to be 18 years of age, a U.S. citizen, and a resident in the district at least 30 days prior to the election. So if they don't meet that criteria, then they're not a qualified elector and they cannot vote in the election. Another reason to set aside a ballot during the judges count is you can't determine the voter's intent by the ballot. And that can look a number of different ways, but kind of a common example is they've, either darkened the oval next to a candidate listed on the ballot, and they've also written in a name for the same office. So they've essentially kind of indicated voted for two people for only one seat. And so that's a problem. We can't determine the intent of the voter on the ballot. And so if a judge runs into that on election night during the judges count, that ballot is set aside for review by the canvassing board on canvassing night. So the school board on canvassing night would then determine, okay, yes, we cannot determine the intent of the voter. You would vote whether or not to count that ballot by motion, second, and roll call vote. So that's what of those rulings, that's what I'm referring to, is if there were any issues with any ballots, if you couldn't determine the voter's intent, those ballots are set aside, and then the school board on canvassing night will then make rulings on whether those ballots should be counted. All right, we got a couple of questions. Okay, good question. This district didn't run their own election. It was on the county ballot, so we have none of the actual material on hand. Do we ask them for answers to questions like how many absentee ballots were asked for? Yes, I think it's important, even if you don't run your own election, I think it's important for the board to receive that information. If any issues occurred during election day, I think it's important to report on those as well. It might require additional planning for your next election if an issue arose. And so I would invite the business manager to report on on how the election went, what went smoothly, was there any issues that arose, did you, was voter turnout higher than expected, are you going to need to maybe plan for more election workers next year or less election workers if you had more than the minimum required. So I think all of those things are important to all those issues are important to report on. Okay. Okay, another question. A voter voted for a school board member but did not vote for whether or not to publish the minutes. Do you count the ballot for the school board member? Great question. So a voter doesn't have to essentially complete every question on the ballot in order for the ballot to be eligible to be counted. A voter can choose not to vote for somebody for a particular office, but then answer a question on the ballot. So the answer is yes, you can still count the ballot. So if they indicated an intent to vote for somebody, a candidate for an office that's up for election, but chose not to answer the question about whether the minutes should be published, it's okay to then count the ballot for that school board member. It would just be a non-vote for the question. You'll want to indicate that and keep track of that, because then your numbers might not match up in terms of your, number of ballots counted, and then your yes and no, the total of your yes and no votes on that publication question won't match up. And so your business manager will want to make a note of that, we had a ballot that didn't indicate a yes or no vote for that question. And so that's why the totals were off for that question. Okay. Okay, so another question. If a voter makes a bad mark on one candidate that can't be determined, is the entire ballot presented to the board to not count the entire ballot, or just the one seat? and count the remaining seats voted clearly. It's kind of getting to what is kind of a similar question to what was just asked. So my understanding of the question is, you have multiple offices up for election. Under one of the offices, you can't tell the voters' intent. You can't determine who they voted for that particular office, but you can make a determination for the other offices on the ballot. Yes, and I think there is a section in the code that talks about, you know, a voter's intent, you know, if you can determine the voter's intent on other, it doesn't, you know, on if the voter makes essentially a mistake, or you can't determine the voter's intent on one issue on the ballot, it doesn't void the entire ballot for the remaining issues. You can still count the votes for the rest of the ballot if you can determine their intent there. Okay, let's see here. One thing I wanted to mention before I get to the rest of the questions is the other, you know, I was talking about making necessary rulings on the ballots. One of the rulings that's made by the board is regarding any signature mismatches on relative to absentee ballots. So if the business manager has contacted the voter and the voter has cured the defect, you would make note of that, and then you would report on that to the canvassing board on canvassing night. And then the board would make a ruling on each of those ballots whether the defect was cured, or in other words, whether the voter properly confirmed the signature on the ballot. And again, the law requires that if the voter properly cured or properly confirmed the signature, the board is required to count the ballot. So it might seem like somewhat of a formality to go through and make those individual rulings, but it is something that I recommend. You could group some of those together. So if you had some that confirmed and some that didn't confirm, you can you know, group the confirming ones together and have the board rule on those, and then group the ones that didn't cure the defect together and have the board rule on those as well. Kind of you can group them together, or you can do them individually. That's up to you. One question I had that I've had there's a couple of questions on what happens when the county runs your election. Who canvasses the vote? So we have a couple of sections in the code regarding this. Okay. So it kind of depends. The question is, who canvasses the votes? Does the county election board canvass the votes, or does the school board canvass the votes? So there's a section in the code that talks about elections held in conjunction with the county primary election. One of those sections is 15.10924. It talks about that the board can agree with the governing body of the county, or counties if you have multiple counties, to share election costs and responsibilities, including those associated with a canvassing board, election personnel, printing of election materials, publishing of legal notices, and the use of poll books. You are required, if you enter into an agreement for the sharing of election expenses and responsibilities, you would then also agree who is going to be canvassing the votes. So basically you can agree who's going to canvass the votes. I don't know if I have a good sense of how that is happening now, and maybe somebody that regularly has their election with the county can speak up and let me know how it works in your district, but that needs to be decided by the the agreement. I think it is pretty typical I believe this is the case. I think it's pretty typical for the county election board to canvass the results of the election that they run. But I don't think the law requires that. So that's something that you should that should be noted in your agreement with the county as to how the election is going to be run. Even if the county canvasses the election results for the school board, I still think it's important for the board to meet on the on canvassing night and hear and report about and have the business manager report on the election to the school board. I'm just looking to see here. Okay. Yeah, it doesn't state one way or the other. So that leads me to believe that there can be part of your agreement. If you want to still canvass the votes as a school board, that would just be part of your agreement with the county. It looks like Brandon in Grand Forks, we commonly work with the county. This year's election was handled by the county and they are canvassing the vote. And I believe that's how it works in Bismarck as well. Bismarck Public Schools has the county, Burleigh County typically runs their election, and I believe the county election board is canvassing the results for that as well. So thank you for that input, Brandon. But anyway, just to kind of confirm, the agreement, if you hold your election in conjunction with the county, your agreement should dictate who's going to canvass the vote. I think a lot of our districts that hold their elections regularly with the county, I believe it is a county canvassing board that is actually canvassing those election results. Again, I still encourage the business manager to report on the election to the school board, and you can get some of that information from the county. Okay, let's see. So yes, one question, I want to just get to the next slide that answers the question. Business manager, so it is a regular it is a meeting of the board, so minutes are required to be taken. So the answer to that question is yes, you take minutes like any other meeting. The business manager should document all rulings in the minutes. And so any rulings that are made by the board regarding any ballots and how they're to be counted should be documented in the minutes, just like any other vote that the board takes that has to be documented. So the board should be confirming the vote totals for each office and the questions on the ballot, and essentially make a final ruling on who received the highest votes or what the vote totals were on any questions on the ballot. Any individual that's receiving the highest number of votes must be declared elected, and then the board is required to record the result of the election. And then within 3 days after that canvassing meeting, the business manager is required to provide each elected individual written notice of their election and their duty to take the affirmation or oath of office. A question I often get is what happens if the individual that receives the highest number of votes declines the seat or fails to qualify? Maybe they're not a qualified elector in the district. Maybe they're, they don't reside within the district. They're not 18 years of age. Maybe if you have geographic precincts that you pull board members from and they don't reside within the geographic area that's dictated typically by your reorganization plan, or if it's a rural board member seat and the person is not a rural board member, so they don't qualify for the seat, what happens? So essentially what that means is the election failed to fill that seat and it creates a vacancy. And so then that vacancy is then filled just like any other time a vacancy occurs. So it doesn't go to the next highest vote getter. It's a vacancy, and then the board either fills the vacancy by appointment or special election. Typically, it's filled by appointment. If the board wants to appoint the individual that received the second highest votes in the election for that seat, they can choose to do that, but they're not required to give it to essentially the next person in line. I just want to check questions here. Thank you guys so much for your questions. Within 10 days after canvass, the business manager must certify the individuals that are elected and their terms to the county superintendent of schools. So that should be done in writing. The individuals elected must take and file the affirmation or oath within 10 days after receiving that notice of election, and before commencing any duties. So if you are going to be holding your annual election prior to the expiration of that 10 days, that individual, in order to be seated and vote and participate as a board member, must take that affirmation or oath before the meeting. Okay, a couple more questions. Someone received an absentee ballot packet that was mailed out, returned back undeliverable, so they never had the chance to vote. We got it back after the election was over. What do I do with this, and do I need to contact that voter? The law doesn't require you to contact the voter under those circumstances, but I think it is. I don't think it's a bad idea to let the voter know, hey, I just want to let you know we received your absentee ballot packet back as undeliverable. Maybe there was something wrong with the address, and it'd be nice for them to know that for next time so that they don't repeat the mistake if it's their mistake. But it's not something that you're required to do. But I do know that there are business managers that if the ballot is not, if it's an absentee voter, and they didn't get the absentee ballot back in time, the business manager will contact the voter and let them know, although that's not required by law. The only time you're required to notify that an absentee ballot wasn't counted is when the signatures didn't match and the voter didn't cure that defect prior to canvassing. You are required to notify the elector that their vote wasn't counted and the reason for the vote not being, or their ballot not being counted. But otherwise, you're not required to notify the voter. Another question, does the write-in candidate required to have the circle marked next to the name before it is counted? So, in school elections in particular, ballots, sometimes they have ovals next to the candidate name that the voter is required to darken in order to vote for that candidate. And they also have that next to the blank space for a write-in candidate. Just because the oval isn't darkened next to the write-in and you can determine the voter's intent, you would still count that ballot for that write-in candidate. And again, I think there is a section of the code that talks about this in particular. I can grab that here for you really quick. Maria, we asked the question, so give me 2 seconds here. All right. Oh, I thought I had it right at the, maybe it's it's actually under the canvassing section in the title, election title. So chapter 16.115, it talks about ballots being voided and not counted. So this is the section that also talks about if the ballot is not endorsed with the initials of the election judge, the law directs that it's void and may not be counted. The other thing it says is with the exception that a voter must, for paper ballots, darken the oval next to the pre-printed name of a candidate or the name of a write-in candidate written on the ballot. If a ballot is marked so only part of the voter's intention can be determined, the election judges shall count such part. So if the elector votes for more than the number of persons to be elected to any office, the elector's ballot may be invalidated only insofar as the elector's vote for such office is concerned. So that's getting back to what I was saying, that, you know, if they make a mistake on one in one office, and I shouldn't call it a mistake, maybe that was their intent, but if you can't determine their intent for one office, but can for the remaining offices on the ballot, the law directs that you still count the remainder of the ballot. That was something that we had talked about before. The law also directs that a ballot is void and may not be counted if it is impossible to determine the elector's choice from the ballot or parts of the ballot. So again, that kind of directs, if you can't determine, if it's impossible to determine the voter's intent on the ballot is void and may not be counted. If you can determine the voter's intent, you would then, you know, count that ballot, even if they, you know, didn't, you know, darken the circle next to the write-in candidate, but wrote in the candidate and didn't darken any other votes. I think you can go ahead and count that ballot. So great questions. Actually, I'm looking at this language that I just read. And it said, with the exception that a voter must, for paper ballots, darken the oval next to the pre-printed name of a candidate or the name of a write-in candidate written on the ballot. So I'm actually going to backtrack a little. I believe, again, this language is a little goofy that I'm reading. And again, this is in section 16.1-15-01. So the individual that asked the question about darkening the oval next to the write-in candidate, I'd invite you to go look at this language. I believe that it, for paper ballots, where you do have the oval next to it that you're directing them to darken, if they don't darken that oval, even if they've written in the name of the candidate, I think the law directs that you can't count that. Which I don't like that. That seems counterintuitive, but the language here makes me think that in that when you do have the ovals and for paper ballots, even next to a write-in candidate, that oval needs to be darkened in order for it to be counted. Now, I know that there are a lot of ballots that don't have those ovals. They'll have like a check mark, or you know, where you put an X on the line next to it. So the law, you know, that language only talks about darkening the oval next to the pre-printed name or the name of a write-in candidate written on the ballot. So I think the law isn't exactly clear on what happens when you don't have the ovals to darken on your ballots, but it looks like it does require that the oval be darkened next to either the pre-printed name of a candidate or the name of the candidate written in the blank space. So that's an interesting, good questions. Let me see if I had anything. We have about 15 minutes remaining, excuse me, for today. So please feel free to keep asking your questions, but another timely topic is the annual meeting procedure. So you know, after you're canvassing your election results next week, the next big thing on most of your calendars will be the annual meeting in July. That usually, again, matches up with your regular meeting in July. Sometime in mid-July is pretty common, but all that the law requires is that each board hold an annual meeting in the month of July following the election. There are a number of important things that happen at that annual meeting. One of the main things is that the term of office for any newly elected board member begins at the annual meeting. So this means that the term of any board member who is transitioning off of the board, either because they ran for re-election and didn't win, or they chose not to run for re-election, their term ends as of the annual meeting. And what that means is once the annual meeting starts, they're no longer on the board. And so I think we've kind of rooted this practice out for the most part, but it might still be hanging on in a few districts out there. But for a handful of years, I got a lot of business managers were calling me about, where the old board would finish old business at the annual meeting and then seat the new board, and then the new board would then conduct new business. And that's just not what's contemplated by the law. I know that we structure our agendas, a lot of us structure our agendas with old business and new business, but that is not something that's contemplated by North Dakota law. It's not a concept that's contemplated by North Dakota law. It's business is business, whether it's old or new. And so at that annual meeting, any business that's conducted needs to be conducted by the new board. And so the new board should be seated. That should be after the calling the meeting to order and the voluntary recitation of the Pledge of Allegiance. The very first item on the agenda should be seating of new board members. We do have a board regulation that we recommend for a procedure for seating new board members. I've referenced that here on the slide. If you don't have that, or you haven't looked at that, I'd invite you to look at that procedure. It's a very short procedure on kind of how that works. But again, seating of the new board members should start before any business is conducted, because any business that is conducted at the annual meeting should be conducted by the new board. Any board members who are transitioning off, either due to not being reelected or not running for reelection, they're no longer board members as of the start of that annual meeting. Another important thing, let's see. Oh, Taylor, we've had somebody ask to share that board regulation BCAB-BR. I'm not sure if we can get it in the chat here, but we'll do our best to get that in the chat here. The other important thing that happens at the annual meeting is electing your board officers. Every board is required to elect from amongst its members a board president to serve for a one-year term. You are also allowed to elect a vice president, but it's not required by law. So that's also an important thing to do. That's something I recommend doing right after you seat your new board members, so that the new board president can then take over at that annual meeting. Another thing, before I move on, in terms of electing board officers, we did a brunch and learn about school board president, the role of school board president, the responsibilities of school board president. And during that presentation, I talked a lot about some important things to factor in when you're choosing your board president. And we went through their roles and responsibilities. And so those are things to take into consideration when you're voting for your president. Make sure that you are picking an individual that, kind of is going to be able to meet those responsibilities and to lead the board and preside over meetings. And so if you go back to the resources page on our website under the Brunch and Learn tab and scroll through, you'll see, I can't remember what month it was, but I did a Brunch and Learn on school board president. It's something to look at when you're choosing your board president, to make sure that you're, factoring in all of those important criteria. Another thing that occurs at the annual meeting is committee appointments, and these are typically standing committee assignments. Not all boards have standing committees, but I think it's a large majority of our boards in North Dakota do have some standing committees. And so those committees should be staffed each year at the annual meeting. Typically, the board president is making those nominations and then they're approved by the board. Sometimes those committee appointments and assignments don't change from year to year. But obviously, if you have new board members coming on, you'll want to consider what committee assignments are appropriate for those new board members. So, common standing committees are personnel committees, hiring committees, negotiations committees, facilities, building committees, a name for a facilities committee. I know I'm forgetting some really obvious ones that I'm not thinking of right now, but and then we have boards that have, we have ad hoc committee assignments too, where they're special committees for a special issue that comes up. Sometimes those aren't staffed at the annual meeting because we're not aware that they're required yet. But that's pretty typical to do those standing committee assignments at the annual meeting. And then the last thing that you're required by law is to set a schedule of your I said annual meetings. I meant regular meetings, sorry. Set a schedule of your regular meetings for the upcoming year. And then that schedule must be filed with the county auditor or posted on your school district website. That's something that you'll want to confirm. So this is the kind of the minimum requirements for your annual meeting. But you can conduct other business at that annual meeting, but these are the key things that need to be accomplished during that meeting in July. Let's see, I think that's all that I had. So if you have any, additional questions that you want to throw out here in the next couple of minutes, I'll hold on here. Again, we have a lot of good resources on our resources page on our website. We've talked a lot about these topics in prior Brunch and Learns. We have our elections handbook that's online that talks about the canvassing process and the absentee ballot procedure and process. We also have our links to our old bulletin articles, our old bulletins, which have a lot of good information, our legal spotlight articles that cover a lot of these issues as well. So I don't see any other questions coming through. So Taylor, I don't know if you have any information on the next Brunch and Learn. I didn't have any information, but if you want to chime in here and let us know what we can expect for the next one.
Yeah, so unfortunately, we have quite a few good topics that we're still deciding on. And just to let you guys know, July, and maybe you've seen this already, July is, here, I'll get on camera here, just kind of talking to a blank screen. So July, we do not have a Brunch and Learn, so just enjoy the holiday and enjoy the weather. But August, we have quite a few, too many good topics to choose from. But we will be meeting on August 21st. So just stay tuned for what topic we'll be releasing to you guys. And then we'll see you then. And then don't forget that we also have our August, well, not exactly August, but our board member boot camp with DPI on August 1st. So we'll see you then too. And it's on Zoom.
Great. Thank you so much, Taylor. And I appreciate, we had a lot of folks on this time. I really appreciate you guys jumping on and asking your questions. I think it's great to hear what others are experiencing in their districts and to learn from each other. And, if you have any topics that you would like us to cover for a future Brunch and Learn, please email me or email Taylor. We're happy to take suggestions if there's a topic that you would like us to cover. We'd be happy to consider those and to schedule those for future Brunch and Learns. Well, we'll give you 6 minutes back of your morning. But again, we thank you for your time and for your good questions and for your support of NDSBA. With that, we'll let you guys get back to your day. Thank you guys all so much.